Good afternoon, everybody. Welcome in. Welcome in. Wanted to make sure I had my light on behind me. Welcome in, everybody. Give me just 1 minute. I'm going to put the welcome. I like to do the welcome to today's live in the chat, which is going to say tonight's, but that's okay. That's okay. And I did come a little bit early, so I'll let a couple people kind of jump in if they want to join our chat today. We're going to go over some documents that come out. So there's that. And then just got to go. Okay, yep, I did all that. Cool. I wasn't sure. I meant to come in. I was going to come on at 5:15, but then I realized I had an appointment and I have to be there before 7, and I wanted to read through documents. So I was like, okay, that's not going to work. So I decided to come on at 4:45. So it's a little early, but I figured the chat will fill in, or you guys can watch it on replay if you're not here for the live. So, hey, Jan, welcome in. Hey, Deanne. Hey, Judy. So if you guys don't mind just taking a second to hit the like button, all that good stuff. If you're watching on replay, hashtag TitaniumBuilt and let me know your thoughts below about the documents we're getting ready to go over. So if you guys are unfamiliar with the case, we are going to be going over the new set of documents that have come out for the Delphi case. Richard Allen is currently awaiting trial for the brutal deaths of Abby Williams, age 13, and Liberty German, age 14, of Delphi, Indiana. So he was arrested last October 2022, and he's been awaiting his trial date in a prison instead of a jail. But, we talked about that before. Unfamiliar. Oh my gosh, this one's a good one. It's a when it comes to, twists and turns, this one is it. So basically the story goes, Abby and Libby were out on a trail, Monon High Bridge. And they were taking some pictures, just being girls, hanging out for the day before Valentine's Day. And a gentleman, or not a gentleman at all, approached them and forced them down a hill and took their lives in the most brutal way possible. From what we're gathering from court documents, but we don't know if the defense, if what they're saying is true, then these girls, this is going to be like when it comes to the most brutal, this might take the cake, by most brutal. But so there's new documents that came out, so I figured we would go over those and we would just talk about them. Let me pull some up here. One of them I didn't really need. I thought I needed it, but I didn't. I have so much stuff up here. I've got too much stuff. I have like stuff for Brian Kohlberger, for Lisk, for Delphi. I've got a lot of tabs, but that's okay. We'll get through them. That's why I wanted to come and do the Delphi case today, because it is the longest out of all of them, as far as reading goes. And I wanted to get it all out for you guys. So, see, I don't know. I don't know about the Odism stuff. Okay, so the documents in the beginning, because we read through all 136 pages, in the beginning, I was like, whoa, holy cannoli. I was like, if this is true, because they started it off with the crime scene, they went right to the brutality of it. And after reading that and then going into the Odism stuff, I was almost like, okay, maybe something. But it almost seems like at the end of the 136 pages, they kind of just gave up and they just slopped it together. So it didn't seem as much structured. So I don't know. I don't think they can lie really like that on a document. I know that it does say stuff about it in here where they have to you have to have some sort of I guess you have to be able to prove what you're saying, basically. And that's what they're going to say that they're going to be able to do. So we're going to take a look at that. Let me get my little glasses on. And if you're new, welcome in. If you're not new, welcome back. I appreciate you guys being here. Hey, Bonafide. It was very shocking, DM. Yeah, they are very right. Hey, Magic, welcome in. I think I saw Justice Jane. Yeah, I did. Oh, there's something on right there. That ain't going to work. Are you kidding? How do I do that? How? Okay, y'all. Okay. Every pair of glasses that I own that are sunglasses, they are scratched on my right side because that's my side I'm blind on. But I'm like, what am I running into? I don't think I'm running into anything. I think it's just me. I must be doing it with my fingers or something. Because these almost look like they have them on there, and I've never worn these outside of the house. So it's weird. But the things that I'm like, wait, the things that make me say, whoa, hold on. Hey, Livia, welcome in. So let's go ahead and get to reading this one here. See if I can. I don't know if it'll let me zoom in. It might. Oh, that's okay. It did. So I'm going to go through the documents as I got them off the internet. Jan actually sent me these too. But I'm not sure if they're they should be in the order that they came out. So up here at the top, it'll say, this one isn't one we need to look at. That's even better. This is the one that we need to look at. Because I knew that there was one that was old. So that one I was just had on, it was from 9/18. It was whenever the documents came out. I think theirs came out on the 13th, and then the state replied on the 18th, or the motion for Frank's hearing was on the 18th. I'm sorry. So supplemental motion for Frank's hearing is the one that we're going to read today. And this one was filed on October the 2nd. He's almost been in there a year now. I think he went in on the end of the October. So it says, comes now the accused, Richard M. Allen, by and through counsel. Let me put the chat over here. This will help me. By and through counsel, Andrew J. Baldwin and Bradley A. Rossi, and having previously filed his motion for Frank's hearing on the 18th day of September, 2023, now files a supplemental motion, which includes a more detailed analysis of the legal standards associated with the Frank's process. In support of said supplemental motion, defendant Allen states as follows. Number one, on the 18th day of September 2023, defendant Allen filed his motion for Frank's hearing. In paragraph 8 of said motion, defendant Allen made general references to the preliminary showing required prior to the admission of Frank's evidence at the suppression hearing. However, defendant Allen now realizes that he did not articulate in detail the actual burden of proof associated with said preliminary showing. So, number two, to mandate an evidentiary hearing, the challenger's attack must be more than conclusory and must be supported by more than a mere desire to cross-examine. There must be allegations of deliberate falsehood or recklessness or reckless disregard for the truth, and those allegations must be accompanied by an offer of proof. They should point out specifically the portion of the warrant affidavit that is claimed to be false, and they should be accompanied by a statement of supporting reasons. Affidavits or otherwise reliable statements of witnesses should be furnished or their absence satisfactorily explained. Number three, the question becomes, what exactly is the burden of proof associated with the preliminary showing? And I'm not going to read I don't want to read the examples too much to you guys because that might get us confused. Other than maybe the Frank's one. Actually, let me just go ahead and read it. Let me go ahead and read it. We might need to know it. We may need to know it. And I'm just going to put me down here so it's a little easier for you guys to see that. So let's go back up. Where was we at? Okay. The question becomes, what exactly is the burden of proof associated with the preliminary showing? And people versus... Let me get this right. Oops. I think it's Lucent. Okay, yeah, Lucent. The Illinois Supreme Court addressed the issue of burden of proof related to the preliminary showing. In pertinent part, the court stated as follows: Frank expressly states that in order to prevail at the hearing, the defendant must prove his claim of perjury by a preponderance of the evidence. If the preponderance standard is to apply at the hearing, it follows logically that the threshold requirement must be something less. Thus, the precise standard lies somewhere between more denial on one hand and proof of preponderance on the other. Put another way, the preliminary burden must be sufficiently rigorous to preclude automatic hearings in every case. but not so erroneous as to be unachievable. Therefore, Allen's burden could be akin to the well-recognized burden of reasonable suspicion, the lowest of the standards employed in the criminal justice system. Number 4. The purpose of the substantial preliminary showing requirement is to discourage abuse of the hearing process and to enable spurious claims to wash out at an early age. Hold on one second, guys. Hold on 1 second. Sorry about that. Thank you. Thank you, Jan, for gifting a membership and you $5 super chat. Thank you so much for super sticker. I appreciate that so much. Thank you. I thought I heard my phone ring and I was like, oh, I need that because I usually don't take phone calls ever on a live. That's crazy to do to me. But because I don't like to interrupt what we're doing. But I'm trying to get a hold of the dentist. I got some really, really, really good news today. So yeah. And the good news is, I'll tell you the good news, that Ohio State takes my dental insurance. And that's the hospital that I was at when I got my car accident. So there's not more like I'm more better, like nothing other than like me not having any problems with my dental problems. This is the best news for me. So that's why I was like, oh, my phone. I thought I heard it. So sorry about that, guys. So rule number 4, the purpose of the substantial preliminary showing requirement is to discourage abuse of the hearing process and to enable spurious claims to wash out at an early stage. Franks v. Delaware, at its very foundation, the preliminary showing requirement is intended to discourage litigants from utilizing the suppression process as a means of seeking an additional opportunity to cross-examine the state's witness. Hence, the rule requires that defendant assert more than basic allegations. Instead, defendant must offer up affidavits and other supporting documents to prove up defendant's claims that the state actors engaged in conduct that demonstrated intentional or reckless disregard for the truth. Number 5, the People v. Lucent, the defendant was charged with possession of a controlled substance with the intent to deliver. The defendant's arrest was driven by a Chicago police officer's execution and submission of a complaint for search warrant. The complaint was based on evidence provided by a reliable and unnamed informant that the officer claimed to have worked with on numerous occasions prior to filing the complaint. The informant claimed to have visited defendant's apartment and purchased marijuana while inside. The complainant also in detail articulated the reasons why officer found the unnamed informant to be reliable. Based upon the officer's sworn statements, a warrant was issued and drugs were recovered in the defendant's residence. This recovery led to the defendant's arrest and filing of formal charges. Number 6, the defendant responded by claiming that he had an alibi. Attached to his Franks hearing, the defendant included several affidavits signed by defendant's family members indicating that he was at another location at the time the unnamed informant claimed to have rendezvous with him at his house or at his home. Despite the fact that all affidavits offered by the defendant, I feel like I'm losing my voice, defendant were statements from family members and therefore somewhat self-serving, the court still found that the defendant met the threshold requirement to offer up the Franks evidence at the suppression hearing. This is to say, at the very nature of an affidavit and its inherent indication of accountability, how do I say this word? Hold on. Inherent indica of accountability and accuracy was enough to overcome the relatively low standard of proof required to make the preliminary showing required by Franks. Number 7, in this case, defendant Allen has done far more than offer up self-serving affidavits. In fact, the bulk of supporting documentation in defendant Allen's offerings include, but are not limited to, affidavits from law enforcement officers working the case, sworn deposition statements from law enforcement officers, numerous police reports, and audio and video of witness statements taken by law enforcement officers during the investigation. The veracity of supporting material offered by defendant Allen is far more reliable on its foundation than self-serving affidavits offered up by the defendant in People v. Lucent. Therefore, it stands to reason that defendant Allen would likewise meet the required burden of proof for the preliminary showing, such that his Frank's evidence should be admissible at the suppression hearing. Number 8. I hate whenever they do they give you examples in a way, because when you're trying to read them out, it almost it makes it more confusing, I feel like, because you're wait, what are you don't know which case they're talking about when you hear certain things. Number 8, the relatively low legal threshold was also demonstrated in the case of People v. Zamatas. In this case, a police officer sought out a search warrant for defendant's home. The officer alleged under oath that he had received information from a reliable informant, and said informant placed sports wagers with defendant through a specific phone number registered in defendant's name. The officer further swore that he confirmed with the phone company that the phone was in fact registered in defendant's name. In response, a defendant filed a request for Frank's hearing, alleging through his own affidavit that the phone number was not registered in his name, and attached an Illinois Bell telephone bill showing that the number was not registered to defendant. The court found that the affidavit and single supporting document was enough to meet the preliminary showing, and therefore the defendant was entitled to a hearing. Number 9, again, defendant offers up self-serving affidavits supported by a corroborating business record and met his burden as it relates to a preliminary showing. Defendant Allen's memo and attachments amount to far more. Allen offered up dozens of pages of police reports from various law enforcement officers, all of which focus on individuals other than himself, Allen, that could have committed these crimes. Depositions transcripts from law enforcement officers that contain testimony acknowledging that others may have committed these crimes. And finally, both written and recorded statements of witnesses on or near the trail on the day in question who articulated facts entirely inconsistent with those offered up by Sheriff Liggett in his affidavit supporting the search warrant. Number 10, assuming that the necessary threshold showing has been made so that hearing must be met, the next question revolves around who has the burden of proof and what exactly is the legal standard at the suppression hearing. Franks holds that the allegation of perjury or reckless disregard must be established by the defendant by a preponderance of the evidence. This standard and circumstances surrounding evidentiary showing are referenced in paragraphs number 6 through 10 of defendant Allen's motion for Frank's hearing previously filed with this court. And then it's signed. So, I forgot what I was going to say for a second. Let me think what I was going to say. This is this is their reasonings on why they should get this Frank's hearing, pretty much. And they're saying, well, this guy, in this case, he just offered up his own affidavit, and they gave him one. Well, this guy, he just offered up his own sworn statement and a telephone bill, and they gave him a Frank's hearing. We gave you 136 pages. Why are we not getting a Frank's hearing? I think that's kind of what what they were getting to there. But yeah. Hey, Olivia, welcome in. I don't know if I welcomed you in. I think I did, Olivia, but Melinda, I didn't. Hey, Melinda. Hey, Carrie. Welcome in, guys. So, what's this one say? Okay. I just want to make sure I don't read the same document twice. But, so this is the motion for the Frank's hearing. And then I want to see, I don't know which one of these was first. We'll just do this. We'll just go this way. So the next one we're going to read over is the defendant's additional Frank's notice. And this was filed, I had to get this off Reddit. It was filed 10/3/2023. And we'll go through this one. And thank you guys all for being here. Appreciate it so much. Jan, I'm the same way. I always have to read things like 2 or 3 times, I feel like, before I retain it a little bit. Welcome in, baby girl. Welcome in. Okay, so let me see if I can blow this up a little bit for for all of us. Oh, there I am with the trackpad. Look at me go. Well, I did a little bit. Oh, one of these days I'll be better at this. It's kind of probably too close now. There we go. So this is the defendant's additional Frank's notice. Now comes the accused, Richard Allen, by and through counsel Andrew Baldwin and Brad Rossi, and files the following additional information to supplement the Frank's motion and memorandum previously filed with this court on October 18th, 2023. That's wrong. October, they mean September. Man, they can't even get the date right. Because it's October 18th, hasn't happened yet. In support of said notice, the defendant states the following. There it is. That on September 18th, 2023, number one, the defense filed its motion for Frank's hearing as well as a memorandum in support of said motion. Number two, that since filing that motion, the defense has received new discovery that strongly supports the defense belief that Tony Liggett and Unified Command attempted to conceal from Judge Denier and has since even attempted to hide from the defense. The evidence supports that those practicing Odinism were the murders of Abby and Libby. So they're saying they received even more new discovery, even more evidence that supports what they're saying. Specifically, Tony Liggett swore under oath at his August 8th, 2023 deposition that a Purdue professor did not believe that the sticks found on Abby and Libby's bodies consisted of ruins. Furthermore, Sergeant Jerry Holman swore under oath at his August 10th, 2023 deposition that the Purdue professor said that the sticks found on the girls did not represent Odinism or any type of cult worshiping of any type of a group that would have conducted the crime. Number five, because of the findings of this Purdue professor, the Unified Command claimed to have essentially abandoned the Odinism aspect of the investigation into the murders of Abby and Libby. Number six, in response to the defense request to dispose of this Purdue professor on September 6, 2023, the prosecutor, Nick McClellan, told the defense via email, as stated before, we are trying to identify the Purdue professor, but no luck yet. Detective Holman has reached out to the FBI and Purdue. Let me get the next page. And has not gotten a response yet. We will continue our endeavors, but may not be able to identify him or her. Number seven, on September 9th, 2023, the day after the Frank's memorandum was filed, where it was revealed that the Purdue professor was missing miraculously, Jerry Holman found the professor, whose name is Jeffrey Turco, and interviewed him. Oh, we found him now. Number eight. However, in the interview, Jerry Holman apologized to Turco for the 3 to 4 weeks that it took him to sit down and talk to him. Number nine. This means that Holman was aware of the Purdue professor's identity since mid to late August, but nonetheless told Nick McClellan that Unified Command could not locate the Purdue professor, and furthermore, that they would not be able to ever, or would not ever be able to find a Purdue professor. That don't look good. If this is true, that doesn't look good. I mean, it doesn't. If they knew where they was and they were just like pretending like they didn't know, I don't know. Number 10, however, after it was obvious that the Purdue professor would probably out himself as the missing Purdue professor following the Frank's memorandum, Holman went and interviewed the Purdue professor the day after the Frank's memorandum was filed. Number 11, why would Holman and the Unified Command try to hide the name of the Purdue professor, even risking ridicule for the absurdity that they could not remember his name? The answer is obvious once the tape statement was played. I got ahead of myself there for a minute. So it says the answer is obvious once the tape statement was played. So this is now part A. Dr. Turco stated that after viewing the pattern of the sticks on the girls, that it was given that someone was trying to replicate a Germanic runic script. Am I saying that right? I think I am. Furthermore, Dr. Turco consulted with a colleague from Harvard who had even more knowledge on ruins, and this Harvard professor was in agreement with Turco. C. Furthermore, Dr. Turco stated that Odinism is an extreme neo-pagan, neo-heathenism ideology that has right-wing racist connotations. D. Furthermore, Dr. Turco stated that according to 19th century sources, that Vikings practiced ritual killings and sacrifices. Okay, what does that have to do with anything? Okay. Because that kind of took a left turn there. Furthermore, Dr. Turco stated that although he could not necessarily interpret these ruins, that the stick configurations were pretty clearly runic, and that he could certainly imagine that this was somebody's idea, that when you do human sacrifice, you carve runes. There are also poetic sources that would support of that idea that somebody might have come across. That scenario seems entirely plausible to me. I was going to try to make this a little bigger, but there we go. Oh, okay. And furthermore, Dr. Turco discussed how ruins were thought to have magical significance and would be used in incantations and rituals, that is a sacrificial connection in mythology, poetry. These were things, again, where somebody who was sort of an Odin fanboy would likely come across. Number 12. And welcome in, everybody. Welcome in, guys. Welcome in. Hey, Diane, welcome in. If you guys don't mind just taking a second to hit the like button, it really does help. If you're not subscribed to the channel and you would like to subscribe, we'd love to have you too. And welcome in. And I hope you guys are having a great day. So number 12, that on September 8th, September 18th, and September 21st, and September 27th, 2023, the state of Indiana made available to the defense a total of 14 hard drives, 5 flash drives, 3 disks, and what appeared to be hundreds of pages of paperwork. Why are they just now getting that? Number 13, particularly contained in the state of Indiana, September 27, 2023 evidence drop was a thumb drive that contained an interview of a Jeffrey Turco, not marked as a Purdue professor. Number 14, it seems apparent by the timing of events that Tony Liggett and Unified Command knew the Purdue professor's name and wanted to hide his name and his findings from the defense, as Turco's conclusions supported the defense and opposed the prosecution and Liggett and Holman's sworn statements. Therefore, apparently in what seems like a complete harebrained scheme, Holman and Liggett decide to claim that they did not know the professor's name, hoping that this would put an end to the defense looking into the Purdue professor. However, once the memorandum made it clear that the Purdue professor would certainly be found at some point in time, it took Holman one day to locate Dr. Turco and interview him about his findings of 2017. Number 15, again, Franks requires a preliminary finding that law enforcement has acted intentionally or with reckless disregard for the truth when being accused of concealing evidence from the judge who signed the warrant. It would be difficult to find a more outrageous set of facts to support that Liggett and the Unified Command intentionally concealed the Odinite information from Judge Denier. If Liggett and Unified Command were willing to try to get away with concealing a Purdue professor from defense counsel, then it is easy to see that they would have no problem in concealing all the evidence detailed in the Franks memorandum from Judge Denier as well. Wherefore, defense counsel respectfully files his additional Franks notice and would request that this court factor in new findings into its ruling on the defense request for a Franks hearing. And then the last page is just signatures there. I'll grab my drink really quick. Everyone's being so quiet, Jan. I know. I feel like something's going on here. I don't know what's going on, but something's going on, and I want to know. Because I like to know things. So I'm nosy. Let's all admit it. I'm a little nosy. I probably wouldn't do true crime and be in a true crime if I didn't have a true crime channel if I wasn't. Gotta be a little nosy, you know. So this one is going to be motion for discovery deadline, which shouldn't the defense already have all the discovery, or like all of it? You would think by now. What else is there to I mean, it's always an active investigation, but I wonder what else there's to discover, unless the officers are just doing. Since the defense is coming up with all of these allegations, maybe the officers have to go and check out all of these allegations and make sure that none of them are correct and none of them are right, just so that they could shut the defense up. You know what I mean? Like, I think that maybe they have to do that. Like, they have to technically investigate it if someone brings it up, you know. But motion for discovery deadline says comes now the defendant Richard M. Allen by counsel Bradley A. Rossi and Andrew J. Baldwin, and respectfully request that this court set a deadline discovery deadline in this cause in support of said motion. Defendant Allen states as follows. Number one, on October 28th, 2022, the state filed an information alleging defendant Richard Allen committed two acts of felony murder. Two, the jury trial in this cause is set to commence on January 8th, 2024. Number three, throughout this proceeding, the defense has received discovery in the form of external hard drives, thumbnails, disk, and written documentation. The defense has picked up said discovery usually within a day, but no more than 2 weeks of the discovery being made available. Well, 1 day and 2 weeks is a long time. You waited 2 weeks to go get some evidence that they were going to give you, like discovery? Now that has no, the defense shouldn't have done that. But they are, I guess, public defenders for him. Number four, said discovery was provided by the prosecutor to the defense on the following dates, all of which were memorialized in an acknowledgement/receipts executed by the defense and or defense representative on the following dates. So we got an envelope dated December 7th, 2022, envelope dated December 21st, 2022. We got 3 receipts that are dated December 21st, 2022, February 13th, 2023, April 20th, 2023. And that's the discovery received before first round of deposition. And then we got some more. Receipt date, May 2023. Second receipt dated May 23rd, 2023. Receipt dated June 27, 2023. Totaling 16 hard drives, 14 flash drives, and 1 disk. I didn't even know that they used I don't know, flash drives anymore. I mean, I must be really bad at that. What's the thumb? Is that not a thumbnail? That's the one thing I know of. I don't know anything else. I know a hard drive's in your computer. That's all I know. I'm not good with computers. That's why I've got Vincent. And that's why I got him. Welcome in, Cheryl and Stephanie. Hey guys, welcome in. So discovery received after first round of depositions. So they got 4 receipt dated September 8th, receipt dated September 18th, 2023 on both. Receipt dated September 21st, 2023, and receipt dated September 27th, 2023. And that's totaling 14 hard drives, 5 flash drives, and 3 disks. Wow. Sorry, this is blurry a little bit, but yeah, that's a little better. The state of Indiana has indicated, number 5, to the defense that the more recent discovery it has provided, September 8th through September 27th, 2023, may contain some discovery that the defense has already received. If this is accurate, some reviewing the state's itemized of newly discovered evidence, the defense believes that very little of the new discovery has been previously discovered. Number 6, however, the defense has had very little time to compare the new discovery dumps of 14 hard drives, 5 flash drives, and 6 disks received on or after September 8th, 2023, with the older discovery received before September 8th, 2023. Number 7, the defense conducted the first round of depositions in this matter in early August 2023. The defense anticipates conducting at least 30 to 40 additional depositions between now and the trial date, but has been reluctant to set additional depositions until it is confident that it has received all of the discovery, also until it has had a chance to review the vast amounts of newly discovered evidence received on or after September 8th, 2023. Y'all, I couldn't be a lawyer. My patience, no. I would be like, I'm always one of those people, I need a game plan at all times. It's almost to a fault. I couldn't just live life on a whim like that and be like, oh, we'll just change it up as we go. But that's why they're lawyers and I'm not. Oh, I'm glad that your daughter is getting better. So Cheryl, I was to you, Cheryl. Number 8, the September 8th, September 18th, September 21st, and September 27th, 2023 receipts referenced above contained in part discovery that was generated by the state of Indiana after the defense conducted its initial round of depositions. 9, it was during this initial rounds of depositions that the state of Indiana and Unified Command learned that the defense was aware of law enforcement's lack of investigation and focus on certain suspects related to Odism, as detailed in the defense recent Franks filing. Number 10, some of the recent discovery that the state of Indiana has provided is directly related to the Odinism aspects of the case, but was only turned over to the defense after the state of Indiana was aware that the defense was cognizant of the Odinism aspects of the case. I don't know if I said that right, but that's okay. The missing, number 11, the missing Odinite evidence that was finally turned over by the state of Indiana following the first round depositions includes, but not limited to, A, multiple interviews of Elvis Fields, which the defense has reviewed and contains exculpatory evidence that supports the defense theory of Richard's innocence. Okay. B, multiple interviews of Johnny Messer, which the defense has reviewed and contains exculpatory evidence that supports the defense theory of Richard's innocence. Number C, an interview of Rod Abrams, same thing. A letter from the former Rushville investigator Todd Click, which is exculpatory in nature in that it provides the name of an investigator who believes that the evidence strongly supports the certain suspects in Delphi, Logansport, and Rushville committed the murders. This is a letter that the state of Indiana has had in its possession since May 1st, 2023, but only turned over to the defense once the state of Indiana knew that it was only a matter of time before the defense team would learn of its existence. C, a report roughly 85 pages in length that has been reviewed and contains exculpatory evidence that supports the defense theory of Richard's innocence. Said that a little wrong. So the more I blow it up, the more it gets kind of hard to read. That's okay. There we go. Letter F. Letter F. Several search warrants signed by judges in Marion County pertaining to certain internet and phone records, including at least one unknown person who admitted to killing the girls, even providing details unknown to the general public of the crime scene, such as the fact that he used a knife in a way consistent with the manner of death, and also claiming that he used a gun but never fired it. Number 12. Number 12. Yeah, I can't even say it. I don't even know what I'm saying now. Number 12. Having only had a chance to barely touch the surface of the vast amounts of newly discovered evidence that the defense has received in the last 24 days, it is hard to know what other exculpatory evidence may be found in 14 hard drives, 5 thumb drives, and 3 disks. Sorry. As well as the paperwork that was provided since September 8th, 2023. 13, in addition to the vast amounts of newly discovered evidence that has been in the hands of law enforcement and the prosecutor's office for over 10 months since the defense entered their appearances, the defense has also received certain new evidence that was only recently produced. And this is what they're going to say, including. So this is newly produced evidence. A new audio file in which Brad Holder was interviewed by state police in August 2023. B, a new audio file in which Patrick Westfall was interviewed in August 2023. C, a new audio file of Nick Westfall, who was interviewed in August 2023. D, a new audio file in which Jeffrey Turco was interviewed on September 9th, 2023. This is believed to be the mystery Purdue professor described in the Franks memorandum. The state of Indiana was apparently aware of his existence since September 9th, 2023, but did not inform the defense of his existence until the defense found his name in a September 27th, 2023 evidence dump. Man, I hope that's not true. 14, between the vast amounts of old discovery that has been in the hands of law enforcement for over 10 months, including exculpatory evidence that supports the defense theory of Richard's innocence, as well as the Todd Click letter that had been in the hands of the prosecutor since May 1st, 2023, a letter that led to exculpatory evidence that supports the defense theory that Richard is innocent, the defense is concerned that there will be a continual drip, drip, drip of evidence, much which could be exculpatory in nature unless a discovery deadline is set by the court. Of course, the defense is not seeking a discovery deadline on any exculpatory evidence, as the state of Indiana has a continuing obligation to provide exculpatory evidence to the defense when it is aware it possesses exculpatory evidence. 16, the defense is requesting that the prosecution produce all evidence in its possession immediately, and also that the court set a November 1st, 2023 deadline to do so. 17, additionally, based upon the state's recent discovery of new evidence, it is the defense's view that following the defense team's first round of depositions and that the state has reopened its investigation, while defendant Allen takes no exception with the state's reopening its investigation, directing its focus on other suspects in this case. Defendant Allen desires that there be more end to the offering up of new information, as well as perimeters as to when and how the state of Indiana should turn over new evidence stemming from the reopened investigation into the Odism aspects of the case or any other aspects of the case that is still being investigated. Guys, I think I'm losing my voice. I feel like I am. Like I keep losing it a little bit. Sorry, I don't mean to. I've never really lost my voice before. That would be crazy. Number 18, pursuant to, and it gives the code. Defendant Allen acknowledges his responsibility to seek out full discovery under terms of the standing order on discovery. In this respect, and to the conform of the local rule, Defendant Allen directed to Carroll County Prosecutor Nicholas McClellan additional requests for discovery on the following dates. Letter dated August 22, 2023, and letter dated August 28, 2023. Defendant Allen believes that he has received a portion of the discovery requested in the above referenced letters. 20. However, to the best of Defendant Allen's knowledge, he has not received the following discovery that has been requested upon the state and are particularly important, as they may very well contain exculpatory evidence that will support the defense theory of who actually murdered the girls. A. Brad Holder audio and video taped interview from February 17th, 2017, conducted by S.A. Adam Pohl and Hammond police officer Christopher Goatee. The body of the report concerning the interview states the following. Give me just 1 second. I'm going to kick my dog out for a minute because Vincent's getting ready to be home. So I'm going to, before he opens the door and they all go crazy, let me get her out. So hold on 1 second, guys. Sorry about that. Yeah, she ain't going nowhere. She's still behind me. She was like, yeah, I'm not doing that, Mom. I was like, do you want to go out there, Mia? And she was like, I'm cool. So I'll leave you in here, but she's going to act crazy once she hears that front door open. All right, wait, we're about this. The below, so this is the, concerning the interview states the following. The below is an interview summary. It is not intended to be a verbatim account and does not memorialize all statements made during the interview. Communications by the parties in the interview room were electronically recorded. The recording captures the actual words spoken. The defense requests the following, the defense requests the recording so it can utilize all actual words spoken by Brad Holder at his interview. B, additionally, in his August 2023 interview, Holder discusses a second interview with law enforcement that took place years ago. The defense requests all reports and recordings of that interview. C, Patrick Westfall was interviewed on February 19, 2017 by the same law enforcement officers that interviewed Brad Holder 2 days earlier. The defense has not been provided any electronic recording of that interview. D, a report believed to be authored by Purdue professor Jeffrey Turco. Defense has not found this report in any of the newest discovery. C, police report related to Mary Jacobs reporting her brother's confession in person in Carroll County sometime in February or March 2017. So number 21. I keep wanting to say letter now. Number 21. The state of Indiana has indicated that it has not been able to locate items A, B, C, and E in paragraph 20. The state has previously indicated it could not locate the Purdue professor in any reports he had authored, although that may have recently changed. 2022, at the time of the filing, the trial in this cause is just over 3 months away. Defendant Allen understands that there will likely exist additional discovery in the form of audio and video surrounding defendant's detention circumstances, which will continue to be requested and presumably disclosed in the event that the Honorable Court takes no action of Defendant Allen's recent motion for immediate transfer. However, Defendant Allen requests that the state of Indiana be required to offer up the totality of all other discovery no later than 30 days from the date of this request. 23. Without a firm discovery deadline, it is impossible to expect Defendant Allen to be fully prepared for trial as it is difficult, if not impossible, to conduct depositions and to engage in pretrial hearings. I can understand that. If you don't have all the evidence, kind of need all this, you need all your stuff. It's kind of like Idaho, where they're waiting, you know what I mean? Like the defense was waiting on, I don't know if they're still waiting, but they were waiting on things. So very strange. Hey, Alicia. So we stopped reading. So it says, if not impossible to conduct depositions and to engage in pretrial hearings without the totality of all the discovery in this cause being provided to the defense. 24. Trial Rule 26B provides that the defense may obtain discovery regarding any matter not privileged, which is relevant to the subject matter involved in the pending action, whether it relates to the claim of or defense of the party seeking discovery or the claim of defense of any other party, including the existence, description, nature, custody, condition, and location of any books, documents, or other tangible things, and the identity and location of persons having knowledge of any discoverable matter. 25. This investigation has been ongoing for more than 6 years. Again, the understanding that there may be some additional discovery related to Defendant Allen's detention circumstances, there is no reason why the defense should be receiving discovery that has been in the hands of law enforcement and which continues to be quite voluminous at this late stage in the proceedings. The need for a discovery deadline exists. I'm agreeing with this. Wherefore, defense counsel respectfully requests that the court set a discovery deadline no later than November 1st, 2023, as defense counsel believes that the deadline is necessary to, 1, promote Defendant Allen's constitutional due process rights to be confronted and present all the evidence concerning the pending allegations, 2, to promote the need for judicial economy as the trial in this case draws near, and 3, to permit Defendant Allen and his attorneys to be fully informed as they engage in further depositions and pretrial matters in this case. I agree with that. I feel like there should be a deadline. I mean, just a deadline for the discovery to come in. If there's going to be more discovery, just let, then the prosecution needs to let the defense know, like, hey, we can do November 1st, but we're still waiting on blah, 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 blah. And it may take a little longer than that. Maybe they could work something out there, but we'll see what the judge says. So this came out on the 1st. And I don't remember I was watching this. So I was going to play this for us. It's Vinny, of course. And maybe he'll, recap some things. But I think that's probably going to talk about the previous documents. But we can go ahead and watch this. And I think that was all the documents that came out. So I think we're caught up there. And I do have some more updates for some other cases. I won't do them right now. But so we'll be doing an Idaho stream soon and like a Long Island. And probably whatever you guys want to do. I'm sure we'll have some more stuff that we haven't, Maybe we'll do Charlotte. We'll see how we'll check in, make sure that her case is getting the justice it needs and that stuff as well. So we got his face is so funny. Hey, Deb, welcome in.
What's going on in Delphi, Indiana? Now, for those who don't know, Richard Allen has been accused of murdering Abby and Libby. It was a case that was cold for 5 years. There were lots of suspicious people, lots of rumors, and ultimately some guy who wasn't even on the radar who works at CBS in the film developing department ended up getting arrested for the murder. Then we learned a lot more when the defense filed some documents last week. I want to go through really the headline, right? So he's accused of murdering these two girls. They believe they have some forensic evidence involving a bullet. They have an admission by him and some other things, a couple other things. Not a ton of evidence in this case, but they have some eyewitnesses, etc. So they have put forth a completely different look or different story about what actually happened to Libby and Abby. They're not saying there's not evidence to prove the case. They're saying he's innocent, and we know exactly what happened to these two teenage girls in the woods on that day in Delphi, Indiana, near the Monon High Bridge. So take a look, because I'm going to lay it out for you, and it's really a two-pronged conspiracy. That's the gist of this. And it begins with members of a pagan Norse religion called Odinism, hijacked by white nationalists, ritualistically sacrificed Abigail Williams and Liberty German. Odinism is the pagan religion referenced above, and its followers are called Odinists. Odinists, or Odinists here, are enamored of the Viking Nordic culture. Evidence supports that at the crime scene, these murdering Odinists left behind obvious signatures, symbols in the form of runes. These runes were formed with sticks, fashioned with tree branches, and painted using the blood of Liberty German. Sticks and tree branches were deliberately and carefully, proficiently placed on each girl in a certain arrangement mimicking certain runes. At least one of the branches appeared to have its end cut off cleanly by some type of tool, like an electric saw, providing proof of a preconceived plan. Additionally, the blood of Liberty German was used as the paint to mark a tree with a rune that looks similar to the letter F. With a simple Google search, these runes would be identifiable as one of the many calling cards of this pagan religious cult. Okay. They also described the scene where Abby and Libby were murdered. With that information, we put together this graphic. This was not something that they created. We created this based upon their description of what Abby and Libby looked like. And the allegation is that the bodies were posed and these sticks were put in a very specific manner to send some sort of a message. And there was a tree with a marking of what they said was an F. Now, that's the first prong, okay? Is that the Odinists are responsible for the murder in the woods, this ritualistic sacrifice in the middle of the day. I mean, middle of the day. It's not a nighttime ritual. This is a ritual in the middle of the day. Now, another piece of the prosecution case against Richard Allen is that he confessed. Take a look. On April 3rd, 2023, Richard Allen made a phone call to his wife, Kathy Allen. This is when he's incarcerated after being arrested. In that phone call, Richard Allen admits several times that he killed Abby and Libby. Investigators had the phone call transcribed, and the transcription confirms that Richard Allen admits that he committed the murders of Abigail Williams and Liberty German. He admits several times within the phone call that he committed the offenses as charged. His wife, Kathy Allen, ends the phone call abruptly. Big part of the prosecution case. You get arrested, you make the phone call, everything's recorded, it's monitored, and in this case, they're saying he basically spilled his guts to his wife. Now, take a look at part 2 of the Odinite conspiracy connected to this case involving Richard Allen, according to the defense. Normally, corrections officers were within earshot of every conversation between Richard and his attorneys and between Richard and his wife, close enough that Richard would have to be worried about any conversation with his attorneys and with his wife being overheard by corrections officers. Corrections officers even required that Richard Allen be positioned facing the window where the corrections officer was videotaping the attorney visits with the handheld camcorder. This positioning of Richard Allen's body would allow the corrections officers to videotape Richard Allen's mouth as he talked to his attorneys. This is the key. Richard would therefore not be able to privately discuss anything with his attorneys, such as, and this is the quote, "The guards are telling me that my wife and family will be killed unless I call my wife and tell her that I killed those girls." Okay? He is alleging that the guards were threatening to kill his wife and family unless he called them to confess. Why is this significant? Because the defense is also alleging that these patches, the triangles, "In Odin We Trust," were on the uniforms of the corrections officers. You following that? Those patches on the corrections officers, meaning they're Odinites. The two prongs, again, of this conspiracy alleged by the defense. One, the Odinites sacrificed and murdered these two girls in the woods, down the hill from the Monon High Bridge in the middle of the day. And then when he was arrested and incarcerated, he's being guarded by Odinites, who then threatened to kill his family like they had killed, I guess, apparently, Abby and Libby, unless he confessed. They were framing the guy who develops pictures at the CVS. That's the defense. Let's bring in the think tank. Can that be sold in court? Joining us in Englewood Cliffs, New Jersey, criminal defense attorney, former prosecutor Al Wunsch III. Also joining us in Stamford, Connecticut, criminal defense attorney Darnell Crossland. And in Cleveland, Ohio, retired judge, former criminal prosecutor for Cuyahoga County, and judicial fellow at the National Judicial College, Judge Gail Byers. Great to see everyone tonight. Al, I'll start with you. Wait, first, just a show of hands. Don't say anything. Before this, has anyone ever heard of Odinism? Okay. I'll see everyone again. Before this, has anyone ever spoken to an Odinite? Oh, he's pointing at Al. You gotta point the other way, Darnell. No. You haven't spoken one. All right, Al, let me start with you. Can this thing be sold in a courtroom? Does it make any sense? Now, we've prosecuted, I mean, we've seen cases where these crazy conspiracies are prosecuted, like the Doomsday Cult mob. So I know cults and strange beliefs actually exist, but to this extent?
Well, what's interesting to me is that this so-called cult, okay, worships Odin and Thor, okay, and Loki, okay, so we have like the rest of the Marvel comics going forward here. It is a religion or a movement that was sort of adopted by the Nazis, and it is a white supremacist group, okay, that has kind of taken over on it. Now, you have a scenario here that, in Oslo, they had that man that went into the camp and killed all those people. He claimed he was an Odinist, and that he was doing it for that purpose because he was an Odinist. But I can't imagine that a white supremacist group would kill two young white girls. So, I mean, it seems odd to me that if you're going to be a white supremacist group and you have a belief that the whites are superior and that they should not be mixing races, then the last thing you're going to do is kill two white young girls who could grow up to produce other Odinists and other neo-Nazis. So it doesn't make a lot of sense to me. And with regards to the fact that the guy is a photographer, he works at the Walmart or whatever,
CVS,
developing photos at CVS. Okay. We all saw the movie, 1 hour photo, Vin. So it could be actually something that could happen.
All right, Darnell, is this something that you would be comfortable presenting to a... Now, they name specific names as well in the papers. We have not repeated those names on the air, but there are specific people they are going after here. Now, the motivation for these white nationalist Odinists was that apparently, according to someone somewhere, is alleging that one of the girls' mothers may have been dating interracially.
Okay. Well, the first thing I just wanted to request, since we have the honor of having a judge with us today, if Al talks too much, can the judge hold him in contempt on the court TV?
Absolutely.
You know, I much like the Odinists, I'm going to start drinking mead every time we have Darnell speaking. That's the only way to be able to tolerate it.
So Vinny, I think, you know, the funny thing about whether I'm comfortable defending this case is that it sounds like when you take away the Odinists and, you know, all that other stuff, it sounds like the defense is, I didn't do it, someone else did it, and here's the evidence. And if they're saying that there's evidence, DNA evidence or trace evidence of blood or
No, they're saying there's sticks. There's a bunch of sticks that are aligned a certain way. And the prison guards are Odinists, and they compelled him to confess to his wife. They were threatening her life. And he couldn't tell his lawyers anything because they were videotaping him, and he was afraid that they were good mouth readers or lip readers.
So that's the second part of the conspiracy. The first part is, again, we don't have DNA or trace stuff. We have sticks. So now you have to argue to the jury about these sticks, and you got to hope that the jury could follow this argument. Then the second part is true. When we go see clients in jail, they make me sit with my back to the door, and they can look at the person in front of me. They're never videotaping it with a camcorder, but they just want us to sit that way. So if he's saying that they were videotaping with a camcorder and he could tie it to the sticks, then maybe these guards have direct involvement with the murder. All I'm saying is that when you present Odinists and this theory to a jury, they're probably going to be just as shocked as I am, and that's going to make the hard sell.
Judge Gail Byers, your thoughts?
Vinny, I think about the fact that in my days as a prosecutor, although as outrageous as all of this sounds, remember, you only have to convince one juror. And as has been said, this seems like it's completely beyond the pale, right? You've got the idea that there are camcorders, which I'm not even sure where you can purchase one these days, but apparently somebody has a direct line to some old technology. But you've got sticks, you've got camcorders, you've got recordings, you've got lip readers. In this day and age, jurors are really looking for sophisticated evidence that really supports the prosecutor's argument. And so I agree that there's going to be this desire to say, hey, you know, is there anything other than sticks? Is there DNA on the sticks? Are there footprints in the woods? Do they match a shoe print from this defendant or
Let me ask you this.
Else?
Let me ask you this, Judge. And I don't know if they have evidence of it, if they had a photograph of a prison guard with the triangle "In Odin We Trust" patch on it, on his uniform, would that alone, with the rest of the evidence they're going to present, but an actual photo of a prison guard wearing the Odinism patches, how far would that be able to move or potentially move a jury close to reasonable doubt, which would be a reasonable alternative theory?
I think, as we all know, it all depends, right? The question is going to be, did that guard ever work the same shift that that prisoner was there? Did they ever have any contact? How did he know that he had the patch on? So tying all those things together, here's what I think. As outrageous and crazy as it sounds, I think that you could actually piece together some string of a story or explanation as to why this actually might make sense for defense. I just don't know if it gets it over the finish line. But again, all you need to convince is one person beyond a reasonable doubt that it's possible that these Odinites and the rest of the Marvel clan, I guess, committed this murder and not the defendant.
And go ahead, Al, 10 seconds, go ahead.
Well, I'm a DC guy, so I'm going to be looking at Batman and Alfredism as my new cult.
Alfredism.
But-
There you go.
Yes.
Perfect.
But
All right.
it's ridiculous. And where's Noah Syndergaard? That's what I want to know.
Okay.
Okay, so that's all I have for you guys for today for Delphi. I didn't realize, man, time flies. I swear it does. But I have to get somewhere before they close today. And I was looking around to see. We may come back and do a live this evening. I don't know. We'll see how it goes. We'll see how it goes. I know that we have some stuff to do around the house, so it kind of depends on if Vincent feels like painting and doing things of that nature, or if he's just going to kind of take the day off and rest, because he had a rough day yesterday too. Having to deal with me. But like I said in the beginning of the chat, I got some really good news today. The hospital that I went to after my car accident, they do take my insurance. The dental side does. This whole time, the general dentistry don't, but the residents and the students do. So I have an appointment with the residents, and then if the students call me back because they can get me in earlier, I'll go there. But it's a really nice step in the right direction, because if they tell me that they want to do the same procedure as this other dentist, then I'll believe them more, if that makes sense, because I trusted them with my life after my accident, so I could trust them with this. So it's just crazy too. But like I was telling Vincent, with me losing my eye, that wasn't a choice I had to make, because I was in a car accident. It was kind of made for me. So this is like a choice I have to make, more or less, and I don't like making hard choices. So not like this anyway. But I do still plan on doing our members live. I wanted to do it today, so we'll probably either do it tonight or tomorrow. But I'm definitely we'll get it in. We'll get it in there. So I will be back either tonight or tomorrow. But I'll see you guys all later. Have a wonderful day and have a really good evening if I don't see you. Bye, guys.